more specific, I'll compare consumer arbitration with business-to-business arbitration, arbitration between two sophisticated business parties. And there are two types of differences. The first is called pre-contract, pre-dispute difference, and the second would be in the dispute itself, after a dispute arises. The first difference, the pre-dispute difference, is similar to all different clauses, or differences between clauses in consumer contracts and clauses in business-to-business contracts. In business-to-business contracts, we can assume, and this is a good assumption, that the two parties are sophisticated and they negotiated the inclusion or exclusion of an arbitration clause from their contracts according to what they think is good for them. In the consumer case, we cannot make this assumption. We know that consumers very rarely read the contracts, the form contracts that they sign, and therefore we cannot assume that the clause is there because consumers thought in advance that this is a good way for them to solve disputes with the seller, the provider of services. We can assume that this is a clause that was put in there by the seller because it was good for the seller. Okay, so this is a main kind of difference between business-to-business contracts and consumer contracts, and it applies also to arbitration contracts as one species of such contracts. The second difference, as I said, applies at the dispute stage, or after a dispute arises. When we have two businesses, we think that they are more or less symmetrically situated in the dispute resolution process in terms of selecting the arbitral forum or the arbitrators that are going to decide in this case. And they are equally capable in terms of resources and sophistication to present their case to the arbitrator or arbitrators. The same is not always true with respect to consumers. They might not be able to present themselves or present themselves effectively in front of the arbitrator. In many cases, they will not have the financial resources to pursue their claim in the arbitration forum. This depends on various factors, including filing fees and other fees that are associated with the arbitration process. It depends on the location of the arbitration forum, whether they will have to miss a certain number of days at work and fly to some place where the arbitration will take place. There are a series of costs that might prevent consumers from making use of this mode of dispute resolution. A little bit of history. In the United States, the main vehicle for policing, for courts to police arbitration clauses, was the unconscionability doctrine in contract law. And so there was a famous Discover Bank ruling from the Supreme Court of California, which basically said that certain types of arbitration clauses, and specifically arbitration clauses that include class action waivers, that prevent consumers to pursue their claims as a class. These arbitration clauses are in many cases unconscionable and therefore not enforceable. So this is the history. Then the cases went all the way up to the Supreme Court of the United States. The claim there was that the unconscionability doctrine, which is part of state law, of state contract law, is preempted by federal law, and specifically by the Federal Arbitration Act, which this is an act which was designed to make sure that courts do not treat arbitration worse than litigation. There was, a long time ago, there was a general animus among courts to arbitration. The purpose of this act was to prevent this. And through a controversial interpretation of the Federal Arbitration Act, the Supreme Court in the famous Concepcion case, and later bolstered further in the Italian Colors case, decided that the Federal Arbitration Act preempts the Discover Bank rule. And so now state courts cannot use unconscionability doctrine to police arbitration clauses. And so the situation now in the U.S. is that by and large, these arbitration clauses in consumer contracts are immune from any meaningful legal review. There is, however, a possibility that the law will change. And this is, again, it has to be, and it now seems like it is, based on federal legislation. in the Dodd-Frank Act of 2008, following the financial crisis, the Consumer Financial Protection Bureau was granted authority to review and possibly prohibit pre-dispute arbitration clauses in the consumer finance space. The Consumer Financial Protection Bureau has recently completed its study. The law says it has to conduct a study first. It completed its study of arbitration, consumer arbitration in consumer finance. And it is at least possible, maybe even likely, that the CFPB will in fact decide to ban or limit pre-dispute arbitration clauses in the consumer finance space. So if we posit that there is no real question of fact, and we know that the consumer owes a certain amount of money to the bank, there is no question about this, there are no relevant defenses in law that the consumer can bring against the bank. If everything is absolutely clear and it's just a matter of getting somebody to say, yes, you can now collect, then you're right, we should go for the forum that is, that imposes the least costs. And this would be best not only for the banks, but for consumers, for society generally. The problem, of course, is that there are many cases, and we've kind of seen them in the press recently in the US, and I'm sure in other countries as well. There are many cases where it's not so clear. Consumers would want to dispute the bank's claims. And the banks sometimes overreach, sometimes deliberately, and sometimes just because their record keeping is not exactly perfect. And so when we do really need to negotiate and resolve an issue of fact, then the concern is that, again, the consumer will be in a disadvantage in an arbitral forum. The motivation, again, in the US, I will speak to the US context. The main motivation in the US for including these pre-dispute arbitration clauses was to avoid the risk of class action lawsuits. And so what happens is that the banks view this as a very large cost, the cost of doing business, the risk of being subject to these class action claims against them. And so they were looking for ways to avoid this exposure, this litigation risk. And they found it in the form of an arbitration clause. And the way that you see this most clearly is that in many of these arbitration clauses that the banks put in, they write expressly that if the class action waiver component is struck down by the court, then the entire arbitration clause is considered void and invalid. So this tells us very clearly that the reason why they want this is in order to avoid class action. If they cannot avoid class actions, they rather litigate it rather than go to arbitration. Another important piece of evidence we see from research done by Jeff Miller and Ted Eisenberg, and they show that the same companies prefer litigation in their business-to-business contract with their suppliers, but insert arbitration clauses in their contracts with their consumers. And so the general claim that arbitration is always more efficient and low cost doesn't seem to be the whole story. There's something else that explains what's going on, and this is the explanation, the class action waiver issue. And just in terms of the risk that these arbitration clauses might not be enforced, the risk now in the US is much smaller after these Supreme Court cases, and indeed we see a very large increase in the instance, in the appearance of these clauses in consumer contracts across many industries. The argument is, and I need to be very clear, is that the businesses want to avoid class action litigation. It is an open question of whether avoiding class actions is good or bad for consumers. So the banks would tell you that class actions are bad for consumers because they increase the bank's costs of doing business, and these costs will then be rolled on to consumers, and consumers will pay higher prices. And so, of course, on the other side, people will tell you that in the absence of class actions, consumers cannot vindicate their rights at all against the banks. And so class actions are good for consumers. But the empirical data that we have is still very much inconclusive. And so it's not clear which side has the better argument. So there are two ways to answer this question. On the one hand, we can try to make arbitration more friendly to consumers. And the way to do that is mainly through reduced fees, arbitration fees, to make sure that the arbitration is in a location that is convenient to the consumer, to make sure that the arbitrators are unbiased. There have been cases in the US where very large arbitration fora have been found guilty of very deliberate bias in favor of the banks, in favor of the sellers. And the main reason for this is that these banks or sellers or suppliers are repeat players. They always come back again. And this generates a bias in their favor. And so we need to be very careful to avoid these biases through various mechanisms. So that's one set of answers. We can make arbitration more friendly or more unbiased. But the other part of the answer is that if that in many cases in these consumer contexts, the claims that consumers have against the suppliers, and this is different from the collection cases. Okay, so the claims that consumers have against the suppliers are small value claims. Okay, so a certain practice by a very large bank can cause a harm of $30 to, I don't know, 1 million consumers. Now, it doesn't matter how low the fees will be in the arbitration forum, and if they are zero, okay, it will usually be non-economical for a consumer individually to pursue a $30 claim against the bank. Okay, and so the result is that these banks, in some sense, can get away with very broad wrongdoing as long as it harms each individual consumer by a very small amount. Okay, so this is still very valuable to the banks, but it's not valuable enough to an individual consumer to bring a claim, either in litigation or in arbitration. So the only way in which this can become a viable claim is through an aggregation of the claims, through class actions or in other countries, other mechanisms. And so to the extent that the reforms do not allow for such aggregation, then other reforms would not help consumers. Now there are rules in an important arbitration forum in the US that would allow for class arbitration. Okay, so this is something that, again, in terms of reform, this is something that should be considered. It sounds like a plausible avenue for policymakers to consider. If they were to go down that road, then the issues that we would want to police would be, again, the cost of the process to the consumer and the bias or lack thereof of the dispute resolution mechanism in favor of, to make sure there is no bias in favor of the seller. And this is very hard to do when the dispute resolution is internal to the seller and is managed by the seller. So in fact, the way to do this, if we were to go down this road, will basically have the seller hire somebody external to conduct, or at least at the appeal level. If we cannot resolve this immediately, it would have to be an external body, and it then starts to sound very much like an arbitration forum, just under a different name. Actually, some sellers, some banks allow you to do this. They allow you to opt out of their arbitration forum if you want, if you follow a certain procedure. So even if I could opt out, it wouldn't help me, because I would be among a very tiny fraction of consumers who opt out. Okay, and this tiny fraction of consumers who opt out would not be enough to support a class action against the banks, and all the advantages in terms of redress and deterrence would be gone. Okay, so even if I could do something about it, even if I could opt out, it would not help me.
Thank you so much, Professor.
It's my pleasure. Thank you.